Good morning again, everyone. It's great to have you with us today for the 26th Annual Ottawa Employment and Labor Law webinar. For those of you who've joined us in past years, you know we do this every year, and it's something we look forward to. My name is Stephanie Lewis. I'm an employment and labor counsel in our Ottawa office. I'm an experienced bilingual employment lawyer and workplace investigator, and I advise employers on every aspect of employment relationship from hiring to conclusion, including workplace management issues. And I will be your moderator for this session. And along with Catherine Coulter, Colleen Hoey, Julia Dales, and Maggie Sullivan, we make up the Ottawa Employment Group. We would like to start with the important stuff. We want to begin by acknowledging the land on which we gather here in Ottawa is the traditional unceded territory of the Algonquin Anishinaabe people. The Algonquin peoples have lived on this land since time immemorial, and we are grateful to have this opportunity to present and share this time with you in this territory. Before we dive in, if we could move to the next slide, please. This is what we will be addressing today. I will start with improving performance and performance improvement. I came up with that title on my own, guys. What's new and exciting? Employment case law update that Catherine gives every year, and this year is a juicy one. Legislative updates about what is happening right now and what is coming up with Maggie Sullivan. The employer checklist, which is a thing of beauty that Colleen Hoey has created with all of the things you need to think about. She'll go through some of the highlights in her presentation, but there's also a beautiful checklist that will be following along with the materials for this presentation. And last but not least, Julia Dales will be sharing the employer guide to workplace investigations. I will be starting things off with improving performance on performance improvement, and Catherine Coulter has something to say about that.
I absolutely do. And as Steph is our moderator, she will typically introduce each speaker as they come, but I didn't want her to have to introduce herself. So we play games in our office. We play games a lot in this particular group. And one of the games that we played amongst ourselves yesterday was to talk about what would each of us do or be if we could not be a lawyer and we had all the money so that we didn't have to worry about money, didn't have to think about money, all the money, right? And life is open to you. And so where Stephanie ended up is this. She would be sitting somewhere very comfortable, likely a cafe in Paris, with all the baking in front of her, all the pastries, the croissants, you name it, and a stack of books. And when I say books, I mean all the books, all the best books ever written. Fantasy, you name it, they're there. Puppy on her lap and glass of Prosecco. That's Stephanie's dream life, and I'm going to turn it over to Steph, who's going to talk about performance improvement.
That legit is my dream life. And anybody who doesn't understand, we can talk, because there's a better future there for you. So when we talk about performance improvement, just like any other business decision, when you come to it as a business, you're going to think about what you want to achieve as a business, and you're going to approach it from that perspective. And the reason I say that, we'll address it shortly, but some employers need to engage in performance improvement in order to establish cause at law and in order to be able to terminate employees without their consent, without their agreement. And provincially regulated employers don't. So the people who need to establish that, absent negotiations and other factors, are federally regulated employers. And provincially regulated employers can make a choice. Is this a situation where the business cost of performance managing somebody is worth it? Is the juice worth the squeeze? With that in mind, we're going to be discussing some things today. So let's move to the agenda, please. We're going to start with why it's important to document employee performance. Then we're going to move into the legal test, because why are we here if it isn't for the legal test? We're going to start then talking about timing. When is it that you should be starting to discuss performance concerns? Then risks with waiting to address, because, tell you when to start, but what happens if you don't start? Tips for effectively documenting, which is the big one, and that one's probably the most important. Performance improvement plans, pros and cons, and the takeaways. So if we could move to the next screen, please. So as mentioned in the intro, just cause is required to terminate the employment of a federally regulated employee. And that's because of the Canada Labor Code and a Supreme Court of Canada decision in Wilson and Atomic Energy that basically recognizes that unionized employee protections have been built into the Canada Labor Code for all employees. There are other ways to terminate the employment. There are other ways to establish cause, but if you want to get performance-based cause, if you want to establish just cause based on somebody not meeting muster in their performance, you need documents. For provincially regulated employers, what we touched on is you can terminate an employee at any time as long as it is not discriminatory, it is not a reprisal for exercising a legitimate right under an act, and and you provide them with the appropriate amount of notice. So when you're looking at a provincially regulated employee, you're going to think, am I going to embark on the performance improvement process? Because is this person redeemable? If from the outset, the person, no matter what they do, will no longer have your faith as an employer again, if you don't believe they can achieve the standard, then you're going to assess, you're going to do a cost benefit analysis. How much would it cost to terminate them without cause, as opposed to how many business resources and how much time is it going to take to performance manage them to build the cause case? And so with that in mind, let's go back a little bit. Today is not a day about accommodations and human rights protected grounds. So we know that you can't discriminate somebody, you can't terminate them because of any protected ground under any of the human rights codes or legislation across the country. So not because, for example, of their age, their religious affiliation and beliefs, their gender, their race. You can't, those are some of the 13 usual examples that apply in all of these situations. You also can't retaliate against somebody for exercising their legitimate statutory rights. So if somebody brings a harassment complaint, for example, under the Occupational Health and Safety Act, and you turn around and you fire them shortly thereafter, then that would optically be a problem. And retaliation, let's talk a little bit about the word retaliation. It means to treat someone negatively or to enact a negative consequence against somebody because of something they did. So if they brought a complaint that their safety rights weren't being met under the Occupational Health and Safety Act and shortly thereafter were terminated, that optically, absent another reason for termination, could be a problem, which brings us to the last bullet on this slide. If the performance isn't documented, if it's not in writing, and the employee is terminated and they don't otherwise have a reason, there's a hole there, a hole where the why sits. Why was that employee's employment terminated? And they will fill it, they or their lawyer will fill it with the worst possible explanation. So if there's an employee who, let's say, is pregnant, and that employee, quite apart from the pregnancy and not for reasons associated with the medical reality that is a pregnancy, having been through two, I know that that's not an easy process on the body. But quite apart from that, that employee is not meeting other standards and it's not documented and it's gotten really, really bad and it can't wait. I mean, it's hard to imagine a situation where it couldn't wait until after the pregnancy, but sometimes it gets so bad that it can't wait and you're afraid that it's legitimately harming your business and you need to take steps and you haven't documented the things that that employee has not been doing that have nothing to do with their pregnancy that are very, very harmful to the business, and that employee gets terminated. It's easy to fill in the why and say that that employee is going to claim that they were terminated because they were pregnant, which is obviously a protected ground and not permitted under the Human Rights Code. So documenting protects employers against allegations of improper motives for termination, where termination would otherwise be permitted if it was properly documented. Next slide, please. With this in mind, we want to document the performance issues and do so being mindful of what is required at law to establish cause for termination based on incompetence. So when we say performance-based cause, at the end of the day, you can sum it up as incompetence. Somebody really can't do their job, and no matter what happens, they're not going to be able to do their job. In order to establish cause-based incompetence, there are a few considerations. The first is that, and this is actually this is from a court, and every once in a while you get advice from a court that you think this is the most useless advice I've ever gotten in my life. The conduct at issue must be real incompetence. Thanks, court. Not simple dissatisfaction. You can't just be unhappy with the way someone's performing, or you can't have concerns about how they may perform in the future. It has to be real incompetence and right now. And the onus, the responsibility to establish cause lies with the employer. And there's a case name there that it is cited in that case, but that is trite law. It comes up all the time. So if we can move on to the next screen, please. The legal test for proving incompetence, for proving performance-based cause, is set out here. In order to dismiss an employee for incompetence, the employer has to show, on balance, that there is a standard to which the employee must perform. So that can be reflected in a number of ways. It can be reflected in policies. It can be reflected in coaching and training. It can be reflected in the work environment. Not only does there have to be a standard, because everybody has things they need to do their job right, that standard has to have been communicated to the employee, which is again where the documentation comes in, right? Like, we notice that you've been doing this, this, and this. The actual expected standard is this, this, and this, and that this is where the vector is. This is where the difference is. Secondly, the employer needs to show that it gave suitable instruction to the employee. This is from the test. The him is from the test. We know that the legal test isn't gendered in real life. It gave suitable instruction to the employee to enable them to meet the standard. So not only is there a standard, not only is the employee aware of it, but the employee was given the tools they needed to meet it. And the tools need to be more than just coaching and training and awareness and the availableness of the available resources and notification of the available resources. It also means enough time. They need to have enough time to meet the standard. So telling somebody they need to make a change, and if an amount of time would be required to ramp up and the change needs to be effective immediately, that's not going to be considered reasonable in terms of the legal test. And then next, number 3, the employee was incapable of meeting the standard. So this again is part of the documentation. You have to follow up. So you tell them the standard, you tell them you make sure that it's very clear, you offer them coaching and guidance, you confirm what they need to do to improve, and then you follow up. You follow up in writing saying, we've advised you on XY date that you needed to meet this standard. We noticed that, at this time, we've had this discussion on this day, and I want to confirm that you, as of right now, you are and then you give the details of how they are not meeting the standard, and again, what they need to do to improve. And this will come up again during tips. And then finally, the employee needs to know the consequences. It needs to be very clear to the employee that a failure to improve would result in termination of employment. This case is one of the many cases that address these standards, but it's again, pretty trite law. If we can move to the next slide, please. When to start discussing employment performance issues? And the answer is right away. It's right away. Part of managing employees effectively means not only giving them positive feedback as soon as you have it, but it also means giving the constructive feedback, giving praise when praise is due, and letting employees know when they're not hitting the mark and helping them get there. And if you start right away, it becomes part of the culture of their employment. And when it is time to give them the negative feedback, because they're in the habit of receiving the negative feedback doesn't feel punitive. It just feels like part of the experience growth in their life as an employee with the company. So with that said, we say it's never too early to start discussing, and that includes during the probationary period. So even if someone's new, helping somebody when they're new become accustomed to the expectations in the workplace involves feedback. And we say, not only do you start as soon as possible, but when something happens, you do that. As you address the performance issues as they occur, not weeks or months later. And the reason for doing it right away, we address on the next slide. Next slide, please. The risks if you wait are that, 1, you tell an employee that they need to improve after they've been in dereliction of duties for a little while. The employee says, I didn't know. And I'm legitimately in an arbitration right now where an employee engaged in a senior management employee engaged in really foul language against a subordinate and is now suing the company for wrongful dismissal. And that senior employee is saying, I didn't know I wasn't allowed to swear and use slurs at junior employees. It's a whole, but people in the most absurd circumstances will take the position that they didn't know. So addressing it right away removes that element. They can't say that they didn't know. The second is one we already discussed. The natural assumption of an employee who's been terminated is that there must be a hidden reason. If you haven't told them what it is and there are no documented concerns, it must be something you haven't told them. And more often than not, we're seeing plaintiff side claims that it's an illicit reason, that it is discriminatory, that it is a reprisal. Because if you haven't papered the reason, they're gonna fill in that hole. And we're all human. We can all tick the boxes when you're accessing a website to identify which photos have the streetlights, which photos have the motorbikes. We know that it is unpleasant having these discussions, or at least it can be. So telling an employee that they're not performing is not a great experience. No one likes making somebody feel bad, even though that may not be your intention. Telling somebody that they're not performing can evoke really negative reactions from the employee, irrespective of how lovely you deliver that message. Performance management is extra work, which is part of what we discussed when we talked about the cost benefit analysis for provincially regulated employers. Is this worth the effort that it's going to take, or are we going to look at a termination without cause? And you don't want to be accused of harassing. Now, this is something that Julia Dales will talk about in the last presentation of the morning when she gets into workplace investigations and the difference between reasonable use of managerial authority and harassment. If you're delivering a message that someone doesn't want to hear, but you're doing it with respect and civilly and in accordance with good management standards, that's not harassment, but it doesn't stop people from making that claim. But if all of this reasons managers don't like to performance manage, even though we acknowledge this, we further say it gets harder if you put it off. So it's hard to start with, but if you wait, it's harder. Next slide, please. Okay, this is just a pretty picture that shows how managing performance and disciplinary issues fits into the building of a strong, competent employee. And so you're assessing performance, you're providing alignment and direction, you're providing feedback and coaching, and this helps grow an employee into the employee that you need them to be to best serve the company. Next slide, please. So with all of that in mind, you've assessed whether or not you're going to do it. Federally regulated employer, you're probably going to wanna, because Wilson and Atomic Energy, there are other circumstances we've all negotiated, and we know there are other ways to get to cause. But if you're looking at performance-based, you probably want to do it. And if you're a provincially regulated employer and you think this employee is redeemable, we need to put in the work here, or it's so expensive to terminate them without cause that we really need to paper these issues, then these are the tips. First, keep it simple, stupid. Anything written is fine as long as it's clear. You can put it, and you want it dated. So you can put it in a letter if you want, a dated letter, or you can put it, we love an email. We love an email, a nice, lovely drafted email that has a date and time confirmation on it. And if you can get a read receipt, chef's kiss. The goal of performance improvement for an employee who is redeemable and generally is not to scare the employee. So we're going to use language that's accessible and that the employee can understand. When we write it, we're not writing this email like a quick, we're very busy during the day, boop, 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 you're going to do this, right? Period. We're going to write it like it's being written for the record. Like we want the lawyer that the employee may retain in the event that their employment is terminated with performance-based cause, or the adjudicator who's going to hear the unjust dismissal complaint, or the judge who's going to hear the civil claim. We're writing for them to show that we've met all the tests that we talked about. There was a standard, the employee was advised of the standard, they were provided coaching and offers of coaching and feedback, they had sufficient training, they were given enough time to improve, and they knew that if they didn't improve in the period of time that they were given, that their employment would be terminated. We're going to summarize the negotiated terms. So if there are any terms in their employment that they're not meeting, we're going to summarize those in the letter. Any warnings issued, we've advised you on this and this and this day that you needed to improve this. Specific performance measures reviewed. So if you've gone through a policy with them in a meeting, you're going to summarize that, and the performance objectives and goals. You're going to repeat, this is what you need to meet, and we're going to be following up on this. You're going to document the facts, not the opinions. So this is what, like on this day, you showed up late and not in accordance with our attendance policy. Like at this time, this day you showed up late, this day you showed up late. We've had discussions about the lateness and the fact that it cannot continue. All of those are facts. We're not going to get into how them repeatedly being late and interfering with the business's ability to do their job is affecting the workplace. Next slide, please. You're going to include supporting materials, so that way they can't say they had to work for it. Here's a link to the policy. Here's a link to what we discussed. Here is a copy of the training. You're going to include, if there are complaint letters that have led to the performance feedback, you're going to include the complaint letters or at least a summary thereof, because you don't want to like red flag potential conflicts with clients, but you're going to summarize, and in the event that it can be anonymized, maybe you provide a copy. Time cards if the event's lateness, email correspondence with HR confirming the previous discussions. This next one is tricky. So people sometimes think, it's tough. It's tough having these discussions. I've told the person knows now that the job isn't done. We need to follow up and comment on these performance issues for as long as they persist. So I like to recommend to clients that they do it every week. Every week there's a meeting, and in that meeting you discuss the standard and whether there's been any progress and how far there is left to go. You want to offer assistance and coaching in those regular meetings. If there's anything you need, please let us know, or by way of reminder, you have these resources. This gets back to the legal test. You want to provide substantive goals and dates by which they should be met, and you want the one final warning to be clear. And this is very important because it's a step in the legal test. Some people have been known to write, if your private performance does not significantly improve, your employment may be terminated for cause, which leaves it open, right? The employee can argue, I didn't know for sure that if I didn't improve, I would be terminated for cause. And it needs to be very clear that the consequence of a failure to improve is going to result in termination of employment for cause. So we're going to replace that may with will. Next slide, please. The pros. People know what they're getting. They have a clear summary of what is expected of them and what the timelines are. And in the event of litigation, this is the biggest pro for us here at Dentons. It's a clear record of what's transpired. This is why when people call us on the regular and say, oh, someone's really not doing a good job, we say, okay, what's in writing? Because that's what the record is in the event of litigation. And the cons, and these are cons that will not be surprising to anybody on this call. It can lead to an employee to experience stress and go on a disability leave. That happens. It's a pretty irregular occurrence. An employee can refuse to agree to a PIP or sign it. Hack. Pro tip, they don't need to sign it. They've been told what the expectation is. It's been communicated to them. They've been told what the standard is. They've been offered feedback and coaching, and they've been told that if they fail to improve, it will result in the termination of their employment. They don't have to sign it. If the employee doesn't sign it, you write to them in writing, because it's like a tree that falls in the forest when no one's around to hear. Did it make a sound? You're going to write and follow up and say, we confirm that you've refused to sign it, but we also confirm that these continue to be the expectations, and we will be holding you to this standard, and this PIP is in effect. And then finally, the employer needs to carefully monitor and assist with the performance managing process, which is what we were talking about at the beginning, right? We were talking about, you're going to do a cost benefit analysis. Is the juice worth the squeeze? Next slide, please. And these are the takeaways. I'm on time, guys. Giddy up. In order to establish performance-based cause, whether federally regulated or provincially regulated, you need the docs. You need the documentation to back it up. The documentation should be provided promptly, so as it happens, and drafted clearly as though it will be read by others. The consequence of failure to improve needs to be clear and unambiguous. You will be terminated your employment will be terminated for cause based on your performance. And the last takeaway, and this is my favorite of the takeaways, it can be difficult to establish performance-based cause, but that doesn't mean you need a perfect case in order to run it. You need to take calculated risks. Sometimes, even though the case isn't perfect, the employee just can't stay in the workplace. The harm of having them there is greater than the harm of dealing with the litigation. And that's what we at Dentons are here for. And with that, those are our thoughts on improving performance on performance improvement. And with that, I pass you over to Catherine Coulter, who will be speaking to you next. But before Catherine starts to speak, Catherine, our fearless leader, if she had all the money in the world and didn't need to work, we've decided. So before asking Catherine what her real answer was, we all decided that she would be a travel blogger. And then Catherine said, maybe I'd just be a travel writer, but we all know that in 2025, those are the same thing. She also said she would be a baker, but I don't think that counts because Catherine is such a good baker. She brings us baking every Tuesday that she could actually make money from that. So it doesn't actually meet the criteria. If she didn't need to make money, what would Catherine do? And so with that, our fearless traveling blogging writer of a baker will speak to you on what's new and exciting in employment case law in 2025.
Thank you, Stephanie. First slide, please. We are going to start out by talking about the confusion that exists, particularly in Ontario, but a little bit across the country when it comes to termination provisions. And this is probably not going to be a surprise to some of you. What is going to be a surprise is the case law that has developed this year, in 2025, which makes it all even more confusing. Can I have the next slide, please? This is just a refresher. I'm not going to go through it except to highlight the last point. You're all going to get this PowerPoint, all of the PowerPoints, as well as this presentation in a link in about 1 to 2 weeks from today. So you'll have this. I won't go through it. But the last point, it's the famous case of Boxdale and Swegan from 2020. That started all the confusion off. That was the case that said a couple of things. It said if you have a termination provision which contravenes the Employment Standards Act or other employment standards legislation, it's going to invalidate it. More importantly for today's talk, an invalidity anywhere in the termination provision is going to void an otherwise valid termination provision. Put a pin on that. We're going to come back to that. Can I have the next slide, please? So, again, I'm going to take you back, just to give you a tiny bit of context. We have to start in February of last year, the case of default in Ignace. Most of you will probably be aware of it because you will have come to us with employees that need to be terminated, and we've looked at your contracts and said, you're going to owe them more money than you think you are. And why is that? Because you had the words termination at any time in your employment agreement, in your termination provision. And back in 2024, as confirmed by the Court of Appeal, the court said you can't do that because to terminate somebody at any time may undercut the minimum requirements of the ESA. For instance, you can't terminate somebody, as Steph said, due to them having been on a protected leave under employment standards legislation. And you can't terminate them as reprisal for a complaint that they've made under the Employment Standards Act. Therefore, you cannot terminate them at any time, and that invalidates the entire termination provision and allows the employee to get common law notice. Can we have the next slide, please? So, moving forward, now we're into this year. This is where it gets fun. Baker and Van Dolders. In April of this year, and this was a lower court decision, the court in Baker looked at a termination provision with the at any time language and said, yep, we agree with default. That strikes down the termination provision. The employee is entitled to common law notice. This case has been appealed to the Court of Appeal in Ontario, and leave to intervene has been granted to the Ontario Chamber of Commerce, which is quite rare. It happens at the Supreme Court quite a bit, but not at the Court of Appeal, that parties that aren't part of the initial claim get to intervene. So that's going to be very interesting to watch. Next slide, please. So, also in April, we had a different court in the case of Jones and Stride. They looked at the default provision and said that the words at any time in a termination provision don't contract out at the ESA unless you've got the words so in the sole discretion of the employer. In the slide that I showed you on default, it had the at any time language, but it also said in the discretion, sole discretion of the employer. That was missing in the Jones case, and so the Jones case said, we're fine with terminating at any time. That's okay. Now, that termination provision ultimately got struck down, but it was struck down for a different reason. But essentially, Jones said, we don't care if you use the words at any time in your termination provision. Next slide, please. Jumping forward into July, we had a couple of cases. So there was a court in Ontario in the case of Lee and Wayfair. It ignored default and Baker altogether, and it said that the words at any time and for any reason were distinguishable. Didn't give a reason. What's the difference? Anyone? 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 No surprise, Lee has also been appealed to the Court of Appeal, and so we're going to, at some point, have a bunch of case law coming down from a Court of Appeal on this issue. Next slide, please. In August of this year, and this is the last of the cases, we had another court decision in Chan. In that case, there were the words at any time and for any reason. And the court found that that language both parts of the language were invalid because they undercut the ESA. And it again went into a description, and the court essentially said that at the end of the day, whether you're looking at terminating at any time or for any reason, you end up in the same place. Is the reason that you're terminating because somebody came off of a statutory leave of absence? That's no different than terminating them at any time for that same purpose, right? And so the court said, look, any of that language is bad language. That's going to invalidate the termination provision. Why this case is particularly noteworthy in my view, besides the fact that it's got a really great judicial analysis to it, it proves that any part of a termination provision can invalidate the provision as a whole. That takes us back to the Walksdale case. And remember when I said put a pin in it? That's this point. This was in the probationary clause, but that was enough to invalidate the entire termination provision. Can I have the next slide, please? I want to just jump back again one last time. We're already confused anyway, right? So let's just layer on some more confusion. Way back in 2022, and this was before the default case, there was a case called Henderson, Ontario. And in that case, the court had to analyze the for any reason part of a termination provision. And it said that it was fine. So essentially you had Henderson in 2022 saying for any reason is fine. Default comes along in 2024 and says at any time is not fine. And then you have a whole bunch of cases that trickle down starting this year, 2025, that look at for any time or for any reason and say in some cases, yep, it's fine. And in other cases, it's not fine. So where does that leave us? Can I have the next slide, please? I'm going to take a pause here because at the end of the day, it may not matter, it may matter. We have perhaps a new gold standard in Ontario as determined by the Court of Appeal that also came down this summer in the case of Birch and Data Stealth. And in that case, and I've quoted the entire termination provision for you here, there was no at any time language, there was no for any reason language. But what is interesting about this case is that the court said, you know what? We think that this is a fine termination provision, understandable to the employee, restricts them to their statutory minimums. We're not going to interfere here and provide this employee with common law notice. I think that at the end of the day, our job as lawyers is to do analysis of everything that comes before us. I'm not sure that the Court of Appeal got it right, and I'm not sure in relation to the language that I've highlighted here in red. And here's the reason why. Our courts, and in particular our Court of Appeal, have been telling us for years that if a termination provision is ambiguous or difficult to understand by an employee, it's going to be struck down. Now, if you are an employee who does not have an HR hat on, you are not a lawyer, you're signing an employment agreement, you don't know anything about employment law, and you get this agreement, what does that red language mean to you? You've just been told you're going to get your statutory minimums up front in the agreement. And then you get this sentence that essentially says, notwithstanding that, there may be times when you don't get your statutory entitlements. That's what this provision actually says. And if you're a regular employee, how can you possibly understand when you're going to get it and when you're not going to get it? What are those circumstances that are going to invalidate your ability to get statutory entitlements? I think it's the wrong decision by the Court of Appeal. And so while some people are moving to that form of termination provision, it's not one that we recommend. Can I have the next slide, please? So here are your key takeaways. We're going to put Birch to the side for a moment because I don't think that it's a great case that's going to stand up over time. The key takeaways in terms of all of those other crazy cases that I've just referred you to with the at any time and for any reason language boil down to three things. It's really hard to get a termination provision right. This is an area of the law that remains unpredictable, it remains difficult, and it probably always will. And that's because at the end of the day, our courts have not been shy to say that they will do whatever they can in the circumstances to interpret cases in favor of employees because of the power imbalance between employers and employees. So With that in mind, your employment contract template should be reviewed annually, updated as necessary, and we are happy to do that at any time. Can I have the next slide, please? We're going to move on to 3 other very quick cases. One is this first case, Brocklehurst, is from Nova Scotia, and here's why it's interesting. If you take a look at the bottom of the termination provision, the language that I've highlighted in red, it refers to the employee getting minimum notice of termination and severance pay, if applicable, under the Nova Scotia Labour Standards legislation. But there isn't labor standards legislation in Nova Scotia that includes severance pay. Statutory severance pay only exists in Ontario and for federally regulated employers under the Canada Labour Code. What the court said in this case is because there's no statutory severance, that made it ambiguous or difficult for the employee to understand what their rights were. Again, we're back to that whole concept of ambiguity. And they struck it down and they awarded Brocklehurst common law notice. What I would say in relation to this is if you have national employment templates, employment contracts, you need to be very aware of this particular issue when drafting. We try to take care of this issue and to make sure that it's not a problem, but we've seen lots of contracts, national templates that companies have from other sources, which could get you into trouble along these lines. So keep that in mind. Next slide, please. The next case, you get about a 30-second update from me on this. It was an inducement case. As you may know, if an employee, a short-term employee, is entitled to common law notice and they were induced, what the court will do is it will take their period of notice with their prior employer and add it to the period of service with the current employer to come up with the total common law notice period. And so this is used a lot by employee side counsel, the threat of an inducement claim to try to get more money into the hands of an employee. This is the new test, as I see it, that the Ontario court has laid out. And again, you'll have this slide in your possession at a later date to take a closer look at. Can I have the next slide, please? I find this case excellent, to be an excellent case. It's something that we have been hammering home on for a couple of years now. Maggie and I wrote a paper, an insight for our clients on independent contractors, employees, the difference between the two, but also that middle ground that exists in Canada of dependent contractors. And I'm going to add here that Canada, as far as I know, is a unique country in recognizing dependent contractor status. I don't think any other country does this. Certainly not the US, UK, or Australia. So, what's a dependent contractor? It's somebody who falls right in the middle between an employee on the one hand and an independent contractor on the other hand. It's somebody that looks like a contractor for the most part, but is subject to significant control by the company. And more than that, is highly dependent or exclusively dependent on the company for the fees that are earned. And this was a prime case of that. This was a company that did trucking. It provided services to a lumber company for 16 years. It was indeed a company. It filed corporate taxes. It owned and maintained its own trucks. It paid its own expenses. It hired its own drivers. It looked like a contractor. It was an independent company. But 2 things. First of all, the drivers were subject to oversight and occasional discipline by the lumber company. More importantly, the nature of the work that was provided meant that the contractor could only provide services to the lumber company. There was no opportunity for it to earn fees for services from any other company, which is usually the case with an independent contractor. And so the court in this case in BC said, and I think rightly so, look, these guys are dependent contractors. They were dependent for their income on just one company, the lumber company, and therefore they're a dependent contractor. As a result, my recollection is that the contractor asked for 16 months of pay in lieu of notice based on the 16 years that services were provided. The Country Lumber Company said they shouldn't be entitled to anything because they were an independent contractor, and the court sort of split the difference between them, and it ended up providing 10 months of pay in lieu of notice. So that's that, and we're going to move on to the next slide and a different area altogether. So let me just give you a tiny bit of background here. I'm going to be talking, and there are just 2 slides and 2 new cases on this, but before I get into the new cases, let me just very quickly at a high level tell you what the law is like when it comes to employee equity rights after termination of employment. We have basically 2 streams that have developed in Canada in relation to this issue. And it's an issue that hasn't been litigated a lot, so there isn't a ton of case law out there, but we have 2 streams. First of all, we have the Court of Appeal in a case that goes back to 2020 called Matthews and Oceans. And in the Matthews case, the court, it wasn't an equity case, it was an LTIP case dealing with an incentive plan. But the court basically said in that case, if an employee is entitled to common law notice, then what you need to do is determine whether or not, first of all, as a matter of fairness, that all of the employees' compensation should continue throughout that common law notice period, all of their compensation. They didn't talk about equity in particular, but they talked about benefits and other compensation. And then you have to take a look at the plan language, whether it's an LTIP plan or an equity plan, to see whether at the end of the day, it clearly takes away that common law right for those benefits to continue. So that's stream number 1. Stream number 2 arose out of a case called Mickelstein's a couple of years ago in Ontario. And in the Mickelstein's case, the court basically said, and that was the Ontario Court of Appeal, by the way, and they looked at the Matthews and Oceans case, and they said in that case, Mr. Mickelstein's, who had shareholdings, didn't get those shareholdings as an employee, as part of his employment compensation. He was an employee, but they weren't part of his employment compensation. They were just shareholdings that he elected to buy into because he had the right to as an employee, and therefore the shareholder agreements should prevail, that equity agreements should prevail. So 2 very divergent ways that the case law has gone in Canada in relation to this issue. And so that now brings us forward to this summer in Canada. So the first case is Lischuk and KJ Electric. It's an Alberta case. In that case, Mr. Lischuk was a shareholder as well. Under a unanimous shareholder plan, he got really significant bonuses. I mean, we're talking like about $1 million worth of bonuses entitlement based on his percentage of shareholdings. The plan very clearly stated that those bonuses would end effective as of his termination date. The Alberta court took a look at Mickelstein's and said, no, we don't buy that. He was a shareholder in the company by virtue of being an employee. At the end of the day, his bonuses based on his shareholdings were part of his employment compensation. Therefore, we have to follow Matthews and Ocean. And therefore, because he was entitled to 26 months of common law notice, he was actually entitled to damages in lieu of the opportunity to get those bonuses through that 26-month notice period. That totaled $1 million for Mr. Lischuk. And can I have the last slide, please? And that brings us to the case of Wigdor and Facebook. That's an Ontario case. That is from this August, I believe. And my understanding is that Mr. Wigdor is considering an appeal to the Ontario Court of Appeal in this case because it was a lower court decision. But despite the fact that it was a lower court decision, it's quite a well thought out decision at the end of the day. And it's difficult to know, quite frankly, where the Court of Appeal is going to go on this because our Court of Appeal in Ontario has taken both sides of this issue. They've taken a Matthews and Oceans approach in an old case involving IBM that predated Mickelstein's, and then they followed the Mickelstein's shareholder approach. In this case, what happened is that Mr. Wigdor had a termination provision that said that his RSUs were governed by the RSU agreement, The RSU agreement in turn said that if he was terminated, his rights under that termination provision would end as of the date of notice of termination, unless otherwise required under employment standards legislation. What happened was the counsel for Mr. Wigdor made the argument that that termination provision in the RSU agreement undercut the ESA, and therefore Mr. Wigdor was entitled to common law notice, and he would be entitled to RSU vesting through his common law notice period. And the reason that the council took the approach that it undercut the ESA was that Section 60 sub 1 of the ESA says that all terms and conditions of employment must be continued during the statutory notice period. Section 60 sub 1 applies if an employee is working out their notice period. But that was what they latched onto and said, look, clearly not all terms and conditions are being continued. Those RSUs are not continuing, and that undercuts the ESA. It undercuts Section 60 sub 1, and therefore he's entitled to everything. What the court did was a really in-depth analysis of the ESA, and the court said, yeah, but Mr. Wigdor wasn't given a working notice of termination. He was provided with pay in lieu of notice, excuse me, and pay in lieu of notice is dealt with under Section 61 sub 1. Section 61 sub 1 does not have that terms and conditions of employment language in it. Shocking. In fact, I have to say that that was news to me when I started digging into this, and I've been doing this for 35 years. But it doesn't. All it says is that you have to continue the employee's current wage compensation, essentially, and their benefits. And we know from the ESA that benefits only includes insured benefits. It does not include things like equity plans, as far as the Ministry of Labor is concerned. And so the court said, look, at the end of the day, Mr. Wigdor was provided with pay in lieu of notice. Section 61 sub 1 applies. Therefore, the ESA was not undercut. He's not entitled to common law notice. And we can rely on Matthews and Ocean, the second part of the Matthews and Ocean test, to say that there is a term in the equity agreement that makes it clear and lawfully makes it clear that his rights to equity come to an end as of the notice of termination date. So that's where we stand now. As I say, I think that whether or not Wigdor is appealed, this whole area is ripe for appeal because we have a mishmash of cases, just like we do in relation to the termination cases. It's fascinating for someone that's a law nerd like me, but for all of you, what's really important to keep in mind is make sure that when your corporate folks are working with corporate lawyers on drafting equity agreements, be they RSU agreements, stock option plans, whatever they may be, you probably need an employment set of eyes on those documents as well as on your employment documents, because you don't want to run into a situation where your equity documents undercut your employment agreement termination provision and your employees are all entitled to common law notice, including continued equity vesting, without anybody ever realizing that that was a possibility. I will leave it there and turn it back over to Stephanie. Thank you.
Thanks so much, Catherine. I love it when the explanation on something is, it's clear as mud. It's clear as mud, which is why you need us, so call us anytime. We had a question come in. So before I introduce the lovely and talented and hardworking Maggie Sullivan, we've had a question on performance management, performance improvement. When giving performance feedback in writing, the question is there a risk the employee gets nervous about potential termination of employment and tries to go on disability leave or another leave to avoid being fired? And yes, that's always a risk. We know the disability leave requires a certain amount of medical support. We don't get to know what the actual disability is, but we need to know the person requires medical leave as a result of this disability. You have a right to know what the prognosis is, when the anticipated time of return is. If that leave is medically supported and it is a disability leave, then you're going to send a letter and you're going to say, this letter is to follow up on our conversation of X date. We are in receipt of your medical documentation and confirm that you are currently on a disability leave. We wish you all the best in your recovery, and we'll hold the performance improvement in abeyance until such time as you are medically able to return, so that they don't think that going on leave has gotten them off the hook. There are other best practices and tips, and I'm happy to discuss it at any time. Meanwhile, we are going to hear next from the wonderful Maggie Sullivan. And if Maggie was not a lawyer and had all the money in the world, she could do anything she wanted, she would do two things. She would do one of two things, possibly two things, depending on her schedule in both. She would be a professional Broadway actor. And she adds in, of course, that would also involve her having the ability to sing. And then she would also like to be a professional athlete. And while she would happily be a professional athlete in any sport, one of the ones that she named was tennis. So with that, our Broadway acting, tennis playing, athletic superstar Maggie is going to tell you about the whatchamacallit statutes, legislative updates, what's happening up until now, and what we're anticipating. Over to you, Maggie.
Awesome. Thank you so much, Stephanie. I really can't think of anything better than singing and dancing or playing sports all day for a job. So that's definitely what I would do if I was not a lawyer. But luckily, I do love my job. So I'm going to get right into it, though. And let's just go right to the first slide here. What better way to start up a presentation than with a meme? And this is going to give us a little bit of the lay of the land. So as some of you may know, in May of this year, the Ontario government tabled its 7th Working for Workers Act. And since 2021, in the years prior, 6 prior, Working for Workers statutes have been enacted, all of which have amended the Ontario ESA and a number of other employment-related statutes in the province. In 2024 alone, 3 of those Working for Workers statutes were passed. And the dates on which the changes from those 3 statutes come into effect vary. Some of the changes came into effect immediately in 2024 when the acts were passed. Others have come into force more recently, and some of the changes are still to come. And so I'm going to take you through that in timeline order, starting first with what we have from 2024. Next slide, please. Okay, so as some of you, and likely many of you will know, on June 21st, 2024, the ESA was amended to provide that employers must now have a written agreement with their employees setting out how vacation pay will be paid. And the default under the ESA provides that vacation pay will be paid in a lump sum prior to an employee taking their time off. In practice, however, that is not how most employers typically handle vacation pay. Instead, we often see employers provide continued salary during an employee's time off, or they may tack on vacation pay as a percentage with each regular paycheck. Both are certainly permissible, and this change simply states that that just needs to be put in writing in an agreement between employer and employee. And we find that the employment agreement is often the best way that obligation can be satisfied. In addition, since October 28, 2024, employers have also been prohibited from requiring employees to obtain a sick note when they wish to exercise their ESA sick leave. The sentiment that the government has explained is that they have found that this was putting an undue strain on the healthcare system. And so that's really the rationale underlying that change. Also, since October 28, 2024, the Occupational Health and Safety Act was amended to explicitly confirm that an employer's occupational health and safety obligations extended to remote work and employees working from their home offices. As well, the definitions of harassment and sexual harassment were also amended to explicitly confirm that harassment and sexual harassment can occur virtually, such as through Teams, Zoom, or other electronic means. Now, in addition to those 3, which I think are 3 of the really more pertinent changes that happened in 2024, there were really a host of legislative amendments that came into force in 2024. And I'd be here all day if I wanted to run through all of them, but I've listed a few on the slide there, and we'd be happy to discuss any questions that may come up in relation to those as well. But now I'll move on to 2025. Next slide, please. Okay, so very recently, just a few months ago, on June 19, 2025, the ESA was amended to introduce a new job protected leave, and this is the long-term illness leave. This leave will provide eligible employees with up to 27 weeks of unpaid time off in the event they have a serious medical condition. Like many other job protected leaves, employees must first have 13 weeks of service with their employer. And then once that's satisfied, employees will qualify for this leave if they, as I mentioned, have a serious medical condition, and if their doctor or healthcare practitioner, which is defined on the screen there, issues them a certificate which states that they have a serious medical condition and which sets out the amount of time off that the employee requires from work in relation to that medical condition. Now, from a practical standpoint, we do not anticipate that this will materially change the way most employers conduct their business. It's not the case that employers were previously permitted to dismiss employees who are off work for medical reasons, and now they're not allowed to do that because there's a job protected leave. That was not the case. Instead, it was always the case that employers were required to accommodate employees who had medical issues which constituted disabilities, pursuant to human rights legislation. And so this job protected leave can largely be seen as a codification of what was already naturally occurring in most workplaces, being the accommodation of employees with medical issues and with disabilities. It's also notable that the amount of time off granted under this leave largely aligns with the amount of time off that the federal government will provide income assistance to employees who need to be off work for medical reasons. And specifically, employees can be eligible for up to 26 weeks of income replacement through EI sickness benefits if they need to be off work for illness or disability. And then the 27 weeks offered here is 1 week longer, which typically covers the 1 week waiting period to receive EI benefits. Next slide, please. Another very recent change from this summer, on July 1st, 2025, employers with 25 or more employees must now provide all new hires with certain prescribed information on or before their first day of work. And that information is listed there on the slide and typically includes that basic employment information, such as someone's hours of work, their work location, contact information from the employer, etc. Now, this is required for employers with 25 more employees to explicitly provide this in writing, but even for smaller organizations who may have less than 25 employees, it's probably still a good idea to make sure that this information is clearly communicated to all your new hires in writing. As I mentioned, it essentially consists of that basic employment information that employees will want to be on the same page about. And similar to the vacation pay agreement that I spoke about at the beginning, we find that often the best way to satisfy this requirement is to ensure that all of that information is addressed in your employment agreements. Next slide, please. Okay, so that covers off everything that we have in force as of today's date. And now we have the forward-looking changes that are still to come in the new year. So first, upon the new year, on January 1st, 2026, employers with 25 or more employees must comply with certain requirements as it concerns publicly advertised job postings. First, employers must include compensation details in their publicly advertised job postings. And this includes information related to a base salary, bonuses, and commissions. I will note that this is only applicable, including compensation details, when the expected compensation for a job is $200,000 or less. It's only applicable when it's $200,000 or less. If it's a higher paying job above $200,000, the compensation does not need to be included in the job posting. I'll also note that if a range is provided as opposed to a fixed number for any of those compensation metrics, the range cannot be larger than $50,000. In addition to that, employers must state in a job posting whether artificial intelligence will be used in the hiring process. So if artificial intelligence is going to be used to screen resumes or other application material or otherwise assess candidates through the means of artificial intelligence, that must be disclosed. Job postings can also no longer require that employees have Canadian work experience. Experience, of course, can be required. However, you can't require that be done in Canada. And lastly, a job posting must state whether the job being posted is for a position that is actually vacant. And this would be in comparison to a posting that's put out there sort of to garner interest or see what the resume pool is currently looking like in the job market. Now, given that there's all these requirements for publicly advertised job postings, it's important to understand what a publicly advertised job posting actually is. And the definition is on the screen there, and it's quite broad, and it really includes any external job posting put out to the general public in any manner. There are certain exceptions, though. It does not include a general recruitment campaign that does not recruit for a specific position. It doesn't include a general help wanted sign that is not for a specific position. It does not include a posting for work that is going to be performed outside of Ontario. And there is a fourth one. Let me just go to my slides here. Sorry. And it also does not include a posting that is internal and solely for existing employees of the organization. I'll also note that amendments were also made to the record-keeping provisions of the ESA, and employers must now, for a period of 3 years, retain all of their job postings, retain applications received in response to job postings, and retain information that is provided to applicants in a hiring process. Okay, next slide, please. Also, as of the new year, employers will now need to make sure that they confirm with applicants the outcome of a job interview. And now the key here is that a job interview will actually have to be conducted for this obligation to kick in. And the definition of an interview is on the screen there. It is quite lengthy, so I'm not going to read it out. But as I mentioned, it essentially requires an interview, a meeting face-to-face, whether that be in person or on Zoom. And it won't capture a reviewing of a resume or a reviewing of other application material absent an interview. And that must be provided within 45 days of the interview. Okay, next slide, please. Okay, and so still to come, on a date that we do not have information about, on a future date to be announced, there will be an introduction of another new job protected leave into the ESA. And this is the placement of a child leave. This will provide eligible employees with up to 16 weeks of unpaid time off in the event that they're going to have a child placed into their care through adoption or surrogacy. As I mentioned, similar to many other job protected leaves, employees must have 13 months, weeks, my apologies, not years, not months, weeks of consecutive service with their employer to be eligible. And then employees will be eligible upon the placement of a child, as I mentioned. Now, this is really meant to mirror the pregnancy leave provisions that are already in the ESA. So what we have right now in the ESA is pregnancy leave, which birth parents are able to take, which pregnant employees are able to take for up to 16 weeks. And following that, we have parental leave, which all new parents are eligible to take. And so this will largely align with the pregnancy leave portion of that system and provide adoptive and parents who become parents through surrogacy with a similar leave to birth parents. And one thing I do want to note here is that employers should consider their top-up policies. So if you're an employer who has a top-up policy where you provide a top-up to someone's EI that they receive during pregnancy leave or parental leave or both, you'll want to consider the introduction of this leave and whether you may need to amend your policies or may want to amend your policies in light of the introduction of this leave. Okay, next slide, please. Okay, now that brings us to the Working for Workers 7 Act 2025. It's also called Bill 30, and I'm going to call it for Bill 30 for ease of reference. And as I mentioned, this Bill 30 was tabled on May 28, 2025. And if passed, it will again further amend the ESA and a number of other statutes in the province. Some of those expected changes that may come into effect if this bill is passed is first a requirement for employers who operate a job posting platform to have a procedure in place whereby people can report fraudulent postings, as well as a policy in place where they can explain how they will deal with those reports. Importantly, this will not apply to solely an external job posting platform. So if you have a web page on your website that only advertises jobs internal to your organization, this will not apply. In addition, there will be another new unpaid leave introduced to the ESA that will be applicable for employees who are part of a mass termination. So when employees are part of a mass termination and when they receive their notice, they will get 3 unpaid days of unpaid time off for the purpose of engaging in job searching endeavors. Importantly, this will only be applicable if employees are provided with their notice by way of working notice and not pay in lieu of notice. An amendment's also proposed to provide for the opportunity for longer temporary layoffs. Right now, the maximum temporary layoff period is 35 weeks. And so this amendment will allow employers to institute a temporary layoff for up to 52 weeks with the permission of the Director of Employment Standards. In addition to that, additional penalties have been proposed under both the Occupational Health and Safety Act and the Workplace Safety and Insurance Act. Next slide, please. Okay, so I'm not going to go into this in too much detail, but it is very interesting and important. Again, in this summer, Ontario passed the Digital Platform Workers' Rights Act. Now, this doesn't amend the ESA; it's its own standalone statute, but it introduces ESA-like entitlements for digital platform workers, including the right to a minimum wage, a recurring pay period, the right to be free from reprisal, etc. Very interesting. And we'd be happy to answer any questions if anyone wants more information. But I'll go to the next slide for now. Okay, now looking beyond Ontario at the federal level, there's been a number of changes there as well. A while ago, if we have any federal regulated employers on here, which I'm sure we do, you would know that in February of last year, the Canada Labour Code was amended to provide for graduated notice in the event of a termination without cause. Prior to this, all employees with at least 3 months of service were entitled to 2 weeks, regardless of any increase in tenure. Now the regime is similar to Ontario and other provinces where the notice of termination will increase based on years of service. In addition, last year, the Canada Labour Code was amended to include a presumption that employees will be presumed employees and not contractors. And so if you want to hire someone as a contractor, you have to beat this onus that is now in place. In addition, this summer, the ESA was amended to provide that federally regulated employers are now prohibited from using replacement workers to perform the work of their employees during a legal strike or lockout. This is very interesting, and as you can see on the slide there, violating this prohibition carries a steep penalty of $100,000 per day. Lastly, on a future date to be announced, federally regulated employers will also be required to implement a disconnecting from work policy. This is very interesting. Ontario is the only other Canadian jurisdiction which requires a disconnecting from work policy, and the federal level will soon follow suit. Importantly, both at the federal level and in Ontario, the obligation in this regard does not create a right to disconnect, but instead institutes this requirement for employers to set out their requirements and expectations for engaging in work-related communications outside of work hours. Next slide, please. Okay, and this slide provides an overview of what we have going on in the other provinces. As you can see, there's changes proposed in BC that are similar to a number of the changes I went through today in Ontario. Alberta, there's new policy requirements, and in Quebec, a very large bill, Bill 101, was introduced, which will amend a number of statutes in that province. And I cannot do justice to those changes now, so I won't try, but we'd be happy to connect you with our Montreal colleagues and answer any other questions you have about Alberta, BC, and of course, Ontario and at the federal level. So that's it from me. Thank you, everyone.
Hi, everybody. Welcome back. I have happily taken over moderating duties. Stephanie, our fearless Stephanie, workplace investigator, has headed off to conduct a cross-examination of some poor soul. So I am taking over for the rest of the day. Our next speaker is Colleen. Colleen is going to speak to us on a world-class Ontario employer checklist. Before we get to Colleen, when we asked her the question of what she would do if she had no job as a lawyer to go to and all the money in the world, first of all, she said she would travel, but apparently I had already taken that, so she changed her mind and indicated that she would set up a foundation to hand out money to make the world a better place. And if you know anything about Colleen, you will know that that description fits her to a T. She's an absolutely amazing person, always thinking of others, and a crack lawyer to boot. So, Colleen, over to you.
Good morning, everybody. I know that sounds like a lot, right? Honestly, let's be serious. We'd all be traveling and doing great things, but it would be fun to support other organizations who are doing great work. So with that, I for today's presentation, we are going to be circulating a checklist, and it will be available in the chat for you. And it's meant to be a tool for you to conduct almost like an employment law health check, or if you went to the car to a shop to get your car checked, that 10-point or however many point inspection. That's what this is meant to do. Years ago, I was speaking to a group of business leaders about all the incredible work that their companies, foundations, organizations were doing. And as we're going through all the various employment law obligations, I realized it really can create a barrier or a source of stress for organizations and blocks them from being able to move ahead with some of the great work that they're doing. So set out then to try to create a tool that could be a reference. Meanwhile, Catherine was doing the same here at Dentons, and so this has been an evolving tool, and clients from time to time reach out and ask for this to be built on. It's also the case that we here do get called in on a number of corporate transactions whenever there are corporate transactions, and one of our key roles is to do effectively this, an employment law health check. What is the state of the employment law universe for this particular company that is going to be acquired? And we look at a lot of the things that are in this list, and it matters, right? A company which has employment contracts in place with enforceable termination clauses, which has paid up all of their vacation pay entitlements to all their employees, obviously presents much less risk, and that can be helpful to the companies in the context of their negotiations over price and other items. So it's also the case, if I'm honest, I do love lists, and I find that they give peace of mind, and I am hoping that this will do the same. As you're going through this list, I expect that many of you will have a lot of these things already checked off, and in which case, I hope you can enjoy that pleasure of doing that check. And it's a simple pleasure, but it's often a nice one when you can say, yeah, got that taken care of. Now, if there's things on that list that you look at and you think, oh, I don't know what that is, or we need some help with that, these are all fixable problems. This is something that we are here for, and by all means, reach out and we can help make sure that you have all those items addressed. Now, before you go running, screaming from the room, I don't intend to walk you through what you may see is like a 9-page checklist. What I have done, and we're going to do over the next little bit, is just go through effectively some trivia questions, which help highlight some of the checklist items that I think are particularly important or worth keeping in mind. And no, you do not have to submit any answers. There's no grades. There's nothing like that. But it's just something to basically take a little bit of a different approach to otherwise reading off a checklist, which would not be fun for any of us. So with that, if we can turn to the first slide, please. All right, so as you'll see in the checklist, there's a number of main categories. What it covers is mandatory policies in Ontario, recommended policies, and in that, depending on what sector you are in, you may have other recommended policies that will be important for your specific industry, but there are some general recommended policies as well. There's also mandatory training. What do you need to make sure your employees have been trained in the period? How often is that training required? Posters, which ones need to be given out to people, or do they need to be posted on the wall, handed out? Plans, there's a number of different plans that are required here in Ontario as well. And then there's questions about what do we look at when we're looking at our contracts and manual review. So we'll go through, or the list you'll see has a number of items that you would want to make sure are done. And then the next section is records, and you will see that that's actually a fairly substantive part of the list. There are a lot of records that employers are expected to both provide to employees, but also retain. And there are different rules around time of how long those need to be kept. Again, the list is meant to provide that reference for you so that you can just go through and check it off. Ideally, make it a once-a-year thing, pick a date, and that's your date for annual review. And then there's other, because no good list is complete without that basket clause of other. Next slide, please. All right, so to begin, which of the following are mandatory policies in Ontario? And one thing I should also stress here is this checklist that you have is for Ontario only. There are different rules for federal, of course, and then across different provinces. But this should be a fairly comprehensive, or is a comprehensive one for Ontario. Other provinces would be similar, but there are distinctions. But Ontario, what are the following mandatory policies? And it is possible to check more than one of these boxes, but if you answered, next slide, please, A, B, D, and E, you would be correct. The only one that is not actually mandatory, but certainly recommended, is a human rights policy. A human rights policy can be very helpful in the event there is human rights complaints, and again, setting up expectations, but it is not something that if you don't have one, puts you offside certain rules and regulations. All right, next slide. So here we have what are the mandatory policies. The first one is the occupational health and safety. And then we've got the harassment, violence, and then the harassment and violence program. And this is something that we do see when we are doing some of our corporate reviews, that a lot of times organizations will have both a policy, a harassment policy, and a violence policy, but they won't have the program, which is the how-to of the policy and the program. And so that is another important component that needs to be in there. We've heard about the disconnecting from work, as well as the electronic monitoring policies. And then there is the AOTA, and that is actually called it a plan. It's a plan, put it here under the policies, but it is required. In terms of recommended, we do recommend a privacy policy. While it's not, there are components of privacy that are required for employers, or for organizations. When it comes to employment, there is no specific privacy legislation which applies to employment in Ontario. That said, we do recommend having a policy around privacy with respect to employees in the workplace. Human rights, and then there's general employment policies. What do we mean by that? Well, if you have a vacation policy, for example, and you offer more than the minimum, your company says, okay, there's the statutory minimums, but we offer everybody 4 weeks off the top in terms of vacation. The company may want to then have a policy which sets out, what do you do with that excess policy, the amounts that you're giving that's in addition to the minimum? Because there's a number of different ways that the company could choose to allocate or use that vacation. Likewise, if you have a discipline policy, you would want to, you may want to set that out. The computer device use policy, also particularly important if you have a business where you provide, say, cell phones to your staff, and particularly say if they're in sales roles, and you want to set out what are going to be the rules, the parameters, if an employee leaves the organization. How do you retain and maintain access to that, to those devices or to the information on that device? All things we can talk about, but those are the types of things that are recommended, not required. Next slide, please. All right, another question. Which of the following do not require annual employee training? So we've got the harassment, the violence, the AOTA, and the occupational health and safety. And the answer is, next slide, please, AOTA. And so with that one, that is the Accessibility for Ontario's with Disabilities Act. The requirement is that employers must provide training when employees are onboarded, and there's no requirement to keep up or continue the training. That said, it is recommended to do so maybe every 2 to 3 years, but you will have met the mandatory minimum if you provide that or ensure that training is done that first year. Conversely, it is required to do training on all of those other policies on an annual basis. So that'd be definitely part of your checkoff list, making sure that those are done. And that can be particularly helpful if things go sideways and there is a, there's an incident of harassment in the workplace. to show that the people have been trained and are aware of their obligations under those policies can be very helpful. Next slide, please. All right, how often should contracts be reviewed? Now, Catherine alluded to that earlier, but the first answer, I think, is what we would all like to think is surely once should be enough. We get the lawyers to draft the contract. Why can't that be enough to keep us going? And then there's the next one is every time there's a change in role or salary. Third, we've given up. Handshakes, spit in a handshake is all we're doing now. We're not putting anything in writing or annually. Now, you would be correct on the next slide if you answered B and C. So ideally it's annually, that you're at least looking at your contracts to make sure that none of these types of changes that we're seeing, and we're anticipating more change in the future from the courts, making sure that those contracts and those termination clauses are staying up to date. But if not an annual review, certainly it's a great opportunity every time there's a change in role or salary to say, okay, let's take a look. Let's make sure. It tends to be a little bit easier as well to have a new contract put in front of an employee if there's something that they're clearly seeing in as a benefit, right? It's not just that the termination clause is changing, but they're getting a new role, a new salary, those types of things. All right, next one. Contract check. List 4 items that should be checked when you're reviewing. Now, the list is actually longer than this, but here, let's go to the next slide, and we will see 6 items. There are more things, and you'll see that in the list, some of the other things that could be checked. But certainly, you want to look at the termination clause. You want to look at the probation clause. As Catherine alluded to earlier, a probation clause can, if it's not properly worded, can itself cause the whole contract to fall. Timing of signing of the agreement. So again, when we're reviewing contracts on corporate transactions, this will be something that we really want to pay attention to, is when did the person sign? If they signed a month after they began their employment, unfortunately, unless there has been consideration, that contract is unlikely to be enforceable. And so connected to that, the consideration, was there some sort of, often we look at a bonus or salary increase or some other form of quid pro quo for signing the contract. If you have questions about that and about consideration, please reach out to us. We can help. That can be a whole other topic. You want to know if you have copies of the signed agreement, because if you do not, especially if you've rolled out new agreements and you don't have it, then look for the next opportunity to help make sure that that's addressed, that you have a signed contract. The other piece you want to look at is, do you know, or do we have a copy of the original agreement? What is the original date of hire? And this can be particularly relevant for companies that are acquiring other companies or merging with others. If you are leading HR and you have all these employees, you want to know when were they actually brought on, and not just with this company, but if there was an acquired company, because that initial date of hire will affect their compensation or their entitlement. So it sometimes happens where somebody will say, well, no, they've been with us for 5 years. But in fact, because they were an acquisition, that person's date of service goes further back in time. And so we want to make sure that we're aware of the full sort of scope of what their liability might be in the event of termination. All right, next slide, please. True or false? All right, a clause in the employment manual, so the manual, not the contract, but which undercuts the ESA can render an otherwise enforceable employment contract void. And the answer is true. So again, if we were hearing this morning about the idea that if there is language, and if it's anywhere that is contrary to the ESA, that could undercut the Employment Standards Act, that could end up taking an otherwise excellent employment contract and rendering it void. So what might be an example? Let's say you have an old discipline policy or an abs or an attendance policy, and that policy says if you are late, 5 minutes, 3 days in a row, we can terminate you immediately for cause, period. chances are that would not meet the standard of willful misconduct to allow somebody to terminate for just cause. And so that policy itself would be considered to fall below the standard and put your contract at risk. So we want to not just look at the contracts, we want to look at the policies. And anytime there's language about if you don't comply, this could happen, we want to make sure that we're really careful around that language about the what could happen. Next slide, please. Another true or false. Okay. Effective January 1, employers will need to notify everyone who submitted an application for a job whether the position was filled. And the answer? It's a bit of a yes, is not as bad as that sounded, but still not great. So you don't have to notify every single person who applied. However, there is going to be a requirement that employers will notify all people who have been interviewed within 45 days. And I draw your attention to the fact that it's all people who have been interviewed within 45 days. So if you've got a running interview period, you're going to want to put a sort of a calendar date 45 days from each interview to make sure that you're meeting that requirement, because you could have, you could be looking for a really long period of time to fill that role. And so you will want to make sure that you're letting people know within the time period and not letting that time lapse. You don't want to just let people know necessarily when the job is, once you've filled the role. Next slide, please. Okay, true or false? An employer must immediately inform benefits providers of salary increases. Okay, and the answer to this is true. So, and this will be something, again, just on your annual checklist, people are getting raises. Did you notify the insurer of the raise in salary? Yes or no? And if you've done, excellent. If you haven't, here's the potential consequence. Say you have an employee who has been with you for 10 years. They've been getting steady raises along the way, but you haven't, or the company has not been letting the insurance company know that their salary is increased. As you know, benefits are often tied to salary amounts. So for example, an LTD payment or benefit is often tied to a percentage of your salary. If it's the case that the salary has not been increased or reflected in the insurance benefits, it could be then that the person, when they go to collect benefits, if it's still based on their old salary, is going to be collecting a lot less than they would have otherwise been entitled to had that been properly reported. The reason why that's particularly important for employers is that then becomes an employer problem. The employer has the obligation to make sure that this information is communicated regularly and could otherwise then be found liable for the gap in coverage. Next slide, please. All right, and this is our last slide, but the question is, what is the maximum fine for a first contravention of the ESA by a corporation? And the answer is 100,000. So second offense is 250 and the third is 500. Now, to be clear, we're not seeing the Ministry of Labor handing out a lot of fines immediately on the first time that there's an issue, but we certainly are seeing a trend in all the Working for Workers Act, sort of all the various ones that are coming out. There's been a focus on increasing fines, increasing potential liability on that side. So we anticipate that the use of fines as leverage or as a penalty will be something that we're going to see more of. And so it's something that we want to be mindful of. By following this checklist, hopefully we can help reduce the chance that we're going to be on the receiving end of any of these types of fines, because people will have been in compliance. Again, if there's any questions about anything on that list, by all means, reach out to all of us. We can help. Thank you.
Thank you, Colleen. That was excellent. And the checklist is something I'm sure everyone is going to be looking to on a go-forward basis. So our last speaker of the morning is Julia Dales to talk to us about workplace investigations. When asked about what she would like to do if she wasn't a lawyer and had all the money in the world, Julia indicated that she would like to be a dog rescuer. She has a wonderful dog, Mabel, who we all adore. But she would be a dog rescuer, and in addition, she would be a music producer. For those who don't know, Julia is, in addition to being a fantastic lawyer and workplace investigator, she's a recording artist. And if after the webinar today you're interested, you may want to look her up online on your favorite streaming platform. You can find her singles there. You can find her album there. Julia Dales, over to you.
Lots to unpack there. Big use of the word recording artist, but thank you, Catherine. And Catherine notoriously doesn't love dogs, and so it means a lot to hear you say that you still adore Mabel. Okay, let's get into this. Okay, so we'll suspend reality for a second completely. Imagine that you work in HR or you're in a supervisory or managerial role, and you're sitting in your office and an employee comes to you, and we'll call her Jane, and you guys are just chatting, and she's a fairly new employee, and she mentions to you that she's feeling a little anxious, and she explains that she was giving a presentation yesterday to her boss with other colleagues present, and at the end of the presentation on work she had completed, her boss said that it wasn't at all what he had been looking for in the assignment, and actually used the word terrible. And later that evening, he was sending her messages about the work, and at some point said that, I don't even know why they hired you, to be honest. And so she's telling you this, and she also mentions a few weeks back that he had raised her voice at her. But she says to you, do not tell anyone this. I'm telling you this in confidence. I don't want to cause a fuss. It was just stressing me out, and I want nothing to do with any next steps. Okay, so if we could have the next slide, please. So the goal today, by the end of the presentation, is to help you assess what should be done in that type of scenario, whether or not a duty to investigate has been triggered based on what Jane has said about her supervisor, who we will be calling John. And if an investigation is required, how do we prepare and plan that investigation process? How do you conduct effective witness interviews, make findings of fact, and report on the investigations? So if we could have the next slide, please. So investigations are not just an important tool to protect workers in the workplace, but they also do protect employers, because as we know, we'll often have employees who make claims of harassment or discrimination, wrongful dismissal because they didn't do what they're alleged to have done. And usually the clearest answer in defense to those types of claims is that we conducted a workplace investigation, and either the findings don't line up at all with what the claimant said, or they do, and we responded appropriately, and our investigation procedure was fair and followed all requirements. So let's first talk about why you and when you have to investigate. So there's kind of three big areas of where your duty to investigate stems from. The first is the law. So and today, just to be clear, we're going to be focusing on Ontario. Federally regulated workplaces have a different workplace investigation scheme under the Canada Labor Code. And due to timing, we're not going to be able to get into that in detail. If you have any questions about that, please feel free to reach out to one of us. So in Ontario, under Ontario's Occupational Health and Safety Act, employers are required to have a program that details how they'll investigate workplace violence. And they are also required to investigate workplace harassment in an investigation appropriate in the circumstances, and to inform the individual who has allegedly been harassed of the results of the investigation in writing and any corrective action that was taken. Okay, and you will also have to notify the individual who has allegedly engaged in the harassment. The Ontario Human Rights Code does not expressly state that employers have to investigate allegations of discrimination. However, you are required to, because the case law has been clear under the human rights legislation that if you fail to take proper steps in response to a discrimination complaint, you can be found in violation of the right to equal treatment in employment under Section 5(1) and from harassment and sexual harassment. The next is employer policies. If you have policies in place that set out specific other incidents that you investigate, then you'll need to follow your policies and investigate those topics. And then best practices. So we'll talk a little bit about this, but it may be that you're not investigating harassment or discrimination. You might be investigating a fraud complaint or serious misconduct because it's appropriate in the circumstances and it's going to protect you later on. Next slide, please. So this is just an overview of the investigation process. So essentially, you're going to learn of an issue. You're going to make sure you have clarity on what the issue or allegations are. Those will be put to the person who allegedly engaged in the conduct, and then you will collect evidence, which includes interviewing witnesses, collecting oral evidence, any audio, video recordings. Then you'll make findings based on what you've collected, report those findings, and notify the parties as appropriate. Next slide, please. So workplace violence, there's a definition here on the slide. Something to note, other than traditional forms of physical violence, it also includes verbal threats or behavior that could reasonably cause a person to fear for their safety. And I've also put up the definition of discrimination, which is differential treatment based on a protected ground under human rights laws. Next slide, please. Workplace harassment. So the definition is engaging in a course of vexatious comment or conduct against a worker in a workplace. That includes virtually, and it can include not just it talks about a course of vexatious comments or conduct, but it can include one incident if it's serious enough. And workplace harassment includes sexual harassment, and workplace sexual harassment is not just the normal, what you'd think of a traditional sort of sexual harassment case would look like with, advances and solicitation, but it also includes harassment on the basis of the protected grounds of sex, sexual orientation, gender identity, or gender expression. Next slide, please. And then other serious misconduct. So like I said, if you're going to be taking potentially disciplinary measures against an employee or terminating an employee because you have allegations that they've engaged in misconduct separate and apart from harassment or violence, then it is best practice to investigate. Because if you go and terminate an employee for cause or you use an incident to justify termination, if you haven't actually confirmed for yourselves that that incident took place, you can't properly rely on that as a causal termination, and you're going to be, risking a wrongful dismissal claim. So if we could go to the next slide, please. Let's now talk back about Jane and John. So first of all, based on what Jane said, we're going to have to decide whether or not that what she's disclosed could trigger one of the definitions we've just talked about. So is she disclosing workplace harassment? And a few important guidelines to help you decide and make that decision is that what we'll often hear from clients is, well, the employee didn't make a formal complaint, so we didn't investigate. So really important to note here is a complaint doesn't have to be formal, and a person who raises an issue doesn't have to use the words complaint or harassment or discrimination, and often they might not. And so it's not about receiving a complaint by someone who's experienced something. It's about awareness. So if you become aware of an incident in the workplace that could trigger one of those definitions, you have a duty to investigate. And a complaint doesn't need to be formal. It can be informal. Once you have, someone like Jane come in your office and disclosing these things, that's sufficient to start triggering a duty to at least inquire and potentially investigate. And then even though Jane has said to John, I don't want you to do anything about this, no complainant can be guaranteed confidentiality. And that's because once you start investigating, you're going to have to put enough information to the respondent and witnesses that they can understand what they're responding to. You have to balance how much you're disclosing to each person, and we'll talk a little bit about that. But there needs to be sufficient detail put to the respondent to respond, which sometimes means they're going to have to know the identity of the alleged victim. That doesn't mean you have to tell them necessarily that they're the one that made the complaint, but you might have to disclose their identity. So let's go to the next slide. So when looking at Jane and Jane's complaint to John, or her disclosure to John, important to note is that not all dissatisfaction in the workplace will trigger the definition of workplace harassment. The Occupational Health and Safety Act expressly excludes reasonable action taken by an employer or supervisor relating to management and direction of the workers in a workplace. So if someone is complaining about being performance managed, or I keep receiving feedback and they never seem happy with my work, that just might be because they're being justifiably performance managed. And if you look at the disclosure that's been made and the incident, if you assume everything that has been said is true, if it still doesn't meet the definition of workplace harassment or violence, or one of the definitions we talked about, your duty to investigation won't be triggered. So if someone comes to you and it really is just an issue that they're being performance managed, you can record that for yourself, that this person came to you with these complaints, but nothing in what they've disclosed indicates that anything more than performance management is happening, and you've confirmed that they are under performance management and it's justified. That will cover you off. But if you're unsure at any point, please reach out to counsel, because we can help assess whether or not your duty to investigate is triggered. People can also just not get along in the workplace. It doesn't mean that they are being subjected to workplace harassment. The courts have recognized that normal abrasiveness in the workplace, personality conflicts, people not liking each other, is not going to necessarily constitute workplace harassment. And what's key in looking at, for example, what Jane has disclosed, is there's a line between if someone is being properly performance managed versus if you look at whether the supervisor or manager or person who's alleged to have engaged in the conduct is, for example, targeting that individual unfairly, or using abusive language, or in the way they are providing the feedback, or the feedback is not objectively justified at all, and it's sort of frivolous. Those are the types of things that might push that conduct into harassment, where you would have a duty to investigate. In the situation with Jane, you would have a duty to investigate, because what she has described is sort of more harsh language, late night messages, and just rude behavior that sounds perhaps specific to her. And so that would be something that you would want to at least inquire more with Jane, perhaps get from her the records of the messages she's alleging were sent, and go from there. We'll go to the next slide, please. Another thing to keep in mind is that workplace has we have a broad understanding of the word workplace. So it's not just on premises at the office. It includes work-related functions. It can include offsite communications between employees if the result is that it's extending into the workplace and creating toxicity. And worker also has a broad definition, including contractors and other people acting on behalf of the company. Next slide, please. Okay, so what happens if Jane, as she said, refuses to cooperate after that, what she's told you is disclosed to human resources? Well, what happens is that you'll still have a duty to investigate, and you will need to record that you tried to reach out to the complainant to get more details, and that if you don't hear and receive more details and the complainant doesn't participate, you'll have to proceed with the investigation anyways, and you're going to set all that, you're going to explain that to the complainant. You'll be proceeding with the investigation anyways and making findings based on the evidence to date. The evidence might not give you enough to make a finding. And so the complainant needs to be advised of the consequence if they refuse. If a complainant has left, no longer employed, the same goes. Important to at least try, document the efforts to obtain more information. With a respondent, same thing. If they have left the workplace or are refusing to cooperate, explain the consequence to the respondent that there are allegations that have been made. You are giving them an opportunity to respond. If they don't, you will have no choice but to proceed on the evidence you have and make a finding of fact. Okay, so we'll go to the next slide, please. Okay, so step one, if what Jane has disclosed is insufficient to really start investigating, you'll want to go to her, the investigator that you choose, go to her and get details of the complaint. So dates, locations, times, get enough information that you'll be able to at least assess if there's a duty to investigate and, whether you can ascertain who witnesses might be. Next slide, please. You're going to want to plan your investigation. So when deciding who you want to investigate, it's possible that you have an HR team and someone on the team is trained in investigations and understands the definitions under the legislation and can investigate. If you have a company, for example, that is so small that HR is friends with the complainant or the respondent, then it may be that you have to look for an external investigator, because the key things about workplace investigations is they have to be conducted by someone who's unbiased and neutral, and that there's no appearance of conflict. All other things to consider are, is there a certain expertise required? Like, do you need someone who has more experience in investigations because it's more complex, or you need accounting assistance if it's a fraud investigation, how fast it needs to be completed, budget, things like that. Investigation should be completed as quickly as possible. If you use an investigator who's not trained, who doesn't understand the definitions, then you are opening yourself to risk that a court could find the investigation wasn't properly conducted. Next slide, please. You're going to want to prepare by first looking at your relevant policies and procedures and make sure you're following those. You're going to want to collect preliminary evidence from the complainant, including reviewing the complaint carefully, determine an initial witness list, and start developing your questions. It's easiest to set out each incident really clearly. It's really helpful if you can get the complainant to commit to their complaint in writing. So you speak with them, get an understanding of their complaint, summarize it in clear points, and have them sign off on it. Next slide, please. At the start of an interview, you'll always want to explain your role as an investigator, review confidentiality, non-reprisal, and non-interference obligations of the employee, explain the importance of being truthful. Don't start off with an adversarial or aggressive tone. Remember, you are a fact finder and you are not conducting a criminal investigation. You want to make sure that the witnesses are safe and comfortable, and that you appear completely unbiased and neutral, and that you don't have a preconceived idea of what has occurred, because the courts look to all those things in determining whether an investigation has been fair. We'll go to the next slide, please. So when you are starting a witness interview, you will want to start off with broad questions, and don't use leading questions that suggest the answer to the witness. You want to just say, look, I'd like to ask you about X. Can you tell me about that? What happened next? When you are interviewing a witness who has been identified as having knowledge for a particular incident, don't question that witness about other incidents that may be involved in the complaint. Really ensure that you're proportionate, because otherwise it can look like a fishing expedition. If someone is there to talk about when Jane came to them, don't ask them if, oh, did you also happen to see when, Robert told her her work was bad too? Just keep it to what the witness is supposed to know based on what the information you have, and let them tell you. Also, try your best to protect confidentiality of witnesses and parties as best you can. But again, if you need to disclose something in order to get a response, then you may have to. Next slide, please. Once a witness has given you their best recollection of everything, go back through their narrative, ask them then questions to fill out details where you can be a little more direct with them. Ask one question at a time to keep things really clear. Start listening for inconsistencies in what they're saying, and then go back to those issues and ask them for clarification. Consider if what they're saying is consistent with what other witnesses have said, and you can put those things to them. And remember, silence is a really good trick. It just lets the person keep talking without prompting. Next slide, please. These are just the 7 W's. Good practice to make sure you cross all those off with every incident you're covering in an investigation. Next slide, please. So at the end of the interview, a golden question is to ask if there's anything else the witness believes is important but hasn't come up. That can really cause them to think and give you information you didn't even weren't aware of at all. And it also protects you if a witness said they didn't have an opportunity for a full response or to give you all the information they had. Collect any relevant documents. Remind them of confidentiality, etc. Next slide, please. Once, when you are interviewing the respondent, make sure that they have a clear understanding of the allegations. They're going to need time to absorb them. You don't have to give them all of the specific details that you're going to put to them in the interview, because you'll still want some spontaneous responses, but they need a summary of what they're responding to. You can't, for example, go to an interview saying, we're going to be asking you about 10 incidents of fraud, and then ask them about 20 other incidents of other things and of other fraud. Next question, please. Sorry, next slide, please. Okay, for when you're taking notes in an interview, it's best practice to take verbatim notes as best as possible. Consider whether you want to also record the interview. That's a personal preference, keeping in mind there will then be a full record of the interviews. When you're taking notes, record observations of, it helps to see how someone is when they come into the room. Are they more or less agitated at certain topics or not? But careful with these observations, because we'll talk about credibility assessments, but just watch for if someone's being evasive or really argumentative. Then you're going to prepare a witness statement summarizing what was said and have the witness review and approve it and sign off on it. Next slide, please. Okay, I've just put out some tips if a witness is being uncooperative, but I'll let you review this because we're running a bit low on time. Next slide, please. Okay, when you're assessing evidence, credibility is an important part of fact-finding, but that doesn't mean just writing every personal opinion you have of someone. Remember, write your notes assuming that they will be publicly accessible to the respondent. They aren't yet, but could be if there's litigation, etc. So when you're assessing credibility, don't write something like, this guy seems smug, I think, he's guilty. It's more about, are they internally consistent in what they've told you? Do their story even make logical sense? Do they have demonstrated bias because of a personal relationship? Are they spontaneous in their responses? Are they forthright? Are they really open and giving you lots of information? Do they have records to support what they're saying? If they don't, why? Is it odd that they don't have those records? Things like that. Next slide, please. And then these are what's going to go into an investigation report, overview of the parties, the evidence, and then you're going to make your finding. Next slide, please. When making a finding, just look at what are the undeniable facts based on all the evidence you've collected? What are the facts that you still need fleshing out? You may have to re-interview people, or maybe that your credibility findings help you make a finding with respect to things that may not necessarily be as factually certain. You're going to make a finding based on what more likely happened than not. It's not a criminal investigation. That's the standard. And I think that will be my time. You're going to notify the parties of the outcome. Remember, alleged victims of workplace harassment, sexual harassment, or workplace violence have to be notified of the finding and corrective measures taken. That is my time.
Thank you for spending your morning with us. It's been a real pleasure. We've enjoyed presenting to you our 26th annual Employment and Labor Law webinar, and we hope to see you again next year. Thank you.